Supreme Court of India Palani vs Tamil Nadu State decided on February 14, 2024 SEC Online SC 144 Facts of the case. 1. Palani ran a clinic which on October 13, 2015 was inspected by the officials of the state. The inspection found 29 types of allopathic medicines meant for distribution without the proper paperwork license for sale. Moreover, upon being questioned as to the source of procurement of these medicines, details remained unfurnished. The drug inspector filed a complaint under Section 200 under the sections under Section 18, c, read with Section 27, b, 2, of the Drugs and Cosmetics Act, 1940. The trial court found the case of the prosecution to have been proved beyond reasonable doubt and, therefore, the appellant was sentenced on appeal. The learned additional district and sessions judge modified the order of the Chief Judicial Magistrate inasmuch as it set aside the appellant's conviction under Section 18, c, read with Section 27, b, 2, of the Drugs and Cosmetics Act, 1940 while confirming the conviction and sentence in regard to Section 18, read with Section 28, of the said Act. High Court refused to interfere in the order of ADJ. Findings of the court. In the present case, the punishment imposed is 6 months simple imprisonment with the minimum statutory fine. It is not in dispute that the appellant is a doctor. We notice that this court in S. Affalakshmi vs. State Respondents by the Drug Inspector 2022 SCC Online SC 269 had acquitted a doctor of stocking a small amount of drug as the same was not slated to be equal to selling medicines across the counter in a shop. This offense, as already noted above, was found not proved by the lower appellate court. The only aspect which remains is a non-disclosure of the name of the manufacturer. We find that the quantities of the 29 kinds of medicines recovered from the clinic run by the appellant were of small quantity. In such a situation, non-disclosure of the name of the manufacturer/person from whom the said medicines were acquired cannot be said to be endangering public interest, which obviously is the primary object of the prohibition in law, by allowing the circulation of such substances unauthorizedly. In the attending facts and circumstances, considering that the appellant is a doctor and also keeping in view the observations of this court in Muhammad Jayasuddin, Supra, 1977, 3 SCC 287, we are of the considered view that imposing a sentence of imprisonment would be unjustified, particularly when the intent to sell/distribute under Section 18, c, of the Act has been held unproven. Therefore, we find it fit to modify the impugned judgment, set aside the sentence of imprisonment as awarded, and instead thereof, impose a fine of Rs 1 lakh on the appellant. The appeal is allowed to the extent indicated above.